Okay, just about this seminar today. This is one of 5 seminars that Shelter's organising with partner organisations and funded by Scottish Legal Aid Board to raise awareness of the Homeowner and Debtor Protection Act and some of the arrangements for helping struggling homeowners. Alongside this event and other events that we're doing, there's also training taking place across Scotland, and a series of online resources are being prepared. In fact, there's some of that material already available on the Shelter website. So it's part of a package of things that Scottish Legal Aid Board has funded. Now, from one part, I've been involved in this work from a policy point of view for about 2 years. I was involved in the repossessions working group and also in the kind of processes as the bill went through Parliament. I'm looking at it from a policy point of view. I don't know all the minutiae of the law or court process, but luckily we've got other speakers that can do that. But I'll hopefully try and give you a sense of where this has come from and what it's trying to do. Now, all the presentations you'll see today will all be on the Shelter website as of tomorrow, so by all means take notes, but all the information will be there from tomorrow. Okay. I'll do this is what I'm going to talk about. I'm going to give some background, which will be pretty familiar to most of you. I'll talk about the Repossessions Working Group, which is the policy process that led to the Act. I'll provide a very quick overview of the Act, and I'll talk a bit about implementation, where we're at just now. Now, this context, I guess you could talk for ages about the context for today, and some of this will be very familiar. As you all know, late 2007, early 2008, we had the beginnings of the banking crisis, leading into recession. And we all know from previous times that as soon as recession hits, unemployment goes up, then mortgage repossessions go up. It's one of the kind of laws of the universe that unemployment and mortgage repossessions are pretty linked. How much they're linked determines what other action we take, but they're very strongly linked. Now, there's very good news of the last 2 years in the sense that although repossessions have risen, they haven't risen nearly as much as was predicted. Across the UK as a whole, last year the Council of Mortgage Lenders had predicted initially there'd be 75,000 repossessions. And that subsequently was revised down, and the prediction for this year is around 48,000. So that's substantially lower than was predicted. I guess that's testimony to some of the actions that were put in place very early on by Scottish Government, by UK Government and individual lenders and other organisations like your own to ensure that some of the worst impacts didn't come into play. However, 48,000 repossessions is still an awful lot more than it was in 2003 when the figure was 8,000. So we are dealing with a very, very different climate of far higher repossessions and unlikely to change significantly over at least the short term. The trouble was, of course, that we knew all this was coming. Everyone knew there was going to be a housing market crash at some point. You can't keep having house prices rising well above inflation forever and ever and ever. At least I don't think you can. No one knew when the crash was going to come, which I guess tended to fuel ever-increasing inflation. Now, I've been working in housing since the late 80s, so I'm kind of old enough to remember the last housing market crash of 1990. And I remember being at events where the lender said, we're chastened. We realised that lending on 5 times income multiples and lending at 110% loans was a bit foolish. We won't do it again. Well, unfortunately they did. And a couple of years ago we were still in the land of kind of self-certified mortgages, high income multiples and loans and loans in excess of value. So there's some big challenges, I think, beyond getting out of this problem repossessions. There's big challenges for policy about how do we avoid getting into that kind of situation again in the future, perhaps a bit beyond today. Now I put up this slide as a kind of framework. It's something that Shelter suggested to the Repossessions Working Group, which met about just over a year ago. And the group accepted it, and it's reflected in the Repossessions Working Group's report. And what it's trying to show is there's a range of different ways in which we can help struggling homeowners. It's not just about legislation, although clearly here today we're going to talk about legislative change. For example, point 1, and I think everyone would agree with this, the earlier you can take action, the more successful it is, the least painful it is, and for the individual borrower, but also for other parties as well. So early action is absolutely critical. The second is about how do you provide support to sustain home ownership if early action hasn't been successful and people are in periods of difficulty. Now, the key thing I want to emphasise here is that you look to support people, for example, through things like support for mortgage interest or other schemes which provide financial support or advice if it's appropriate to do so. It may be that in some cases someone just isn't able to sustain their current accommodation or their current mortgage. Now, for me, there's a couple of options there. Either you look at, can they retain that accommodation under different arrangements, things like using mortgage to rent, mortgage to shared equity, and we'll talk about that later on. Or even, in some cases, is it simply that they no longer can sustain that accommodation at all as a homeowner or in other arrangements, in which case we're about trying to ensure there's a smooth transition to other forms of housing rather than becoming a crisis. So what we're trying to see here is there's a number of different ways in which we can help homeowners, and it's not always about retaining people in a mortgage in that home come what may, because it simply may not be sustainable, but it simply may expose them to greater debt and the threat of action in the future. Now, maybe we'll judge at the end of today how well we've covered all 4 of these points in the policy framework that's been developed by the Scottish Government over the last year or so. So this is where we were kind of in 2008, probably late 2008. And the point of this slide is to emphasise that there already was quite a significant package of assistance for homeowners who were going into difficulty with their mortgage. This is really probably towards the end of 2008. And as part of what the UK government was doing, or for England exclusively, there was a mortgage rescue scheme, and we'd already had a mortgage rescue scheme in Scotland for quite a long time. But a mortgage rescue scheme was developed in England. There was support for mortgage interest, which had been around for a long time, although it's tended to vary over time. There was a pre-action protocol for courts in England and Wales to try and ensure that mortgage repossession was the last resort. I'll talk a bit more about the pre-action protocol in a minute. And there was a new homeowner mortgage support scheme, which was a method by which interest could be, if you like, delayed for up to a couple of years with the agreement of the lender to ensure that if there's short-term problems for someone, they could see them through. So these were kind of UK government measures. And in Scotland, by the end of 2008, we'd had mortgage to rent for 5 years. I'd been around for quite a long time, since 2003, and a newly developed mortgage to shared equity programme. We'd had the Mortgage Rights Scotland Act 2001, which had been around obviously, well, I think it was implemented in 2002, been around for quite a while. And we had Section 11 of the 2003 Homelessness Act, which, although it wasn't live at that point, was about to go live. And Section 11 requires lenders or landlords to notify local authorities if a repossession action has been taken. So the idea behind that was to try and ensure there's early warning of potential homelessness. So we had, at this point, quite a significant package of assistance. And some people said, well, actually, this is quite significant. Why do we need to do more? Surely it's about getting this package of things working effectively. They said, well, actually, repossessions haven't been as high as was anticipated, that the recession's already been at its worst, and we don't need to take any other action. But I think that misreads what this package was doing. Irrespective of whether there had been a recession and a rise in repossessions, there was need for reform in Scotland. The Mortgage Rights Act wasn't working as it was intended, mainly because it required homeowners to actually apply to get that protection rather than being provided as a matter of course. So there already was a case for reform, recession or no recession. The Scottish Government agreed with that analysis and set up the Repossessions Working Group in early 2009. So this is a kind of quick outline of the process. The Repossessions Working Group sat for about 4 months involved advice organisations like Shelter, Citizens Advice, Money Advice Scotland, and some of the law centres, involved solicitors, private practice, involved the Scottish Law Commission, Scottish Government officials, and the court service. A number of people with an interest in this area of policy. And it was charged with doing two things. One was specifically to look at the legal framework for helping struggling homeowners in Scotland. And secondly, it was also asked to look at other measures that might help struggling homeowners, things that are non-legislative, if you like. I suppose the important point about the final report that was produced in June 2009 is that legal changes, which are the main focus of today, are only a small part of its recommendations. Here's some of the kind of main ones I picked out. I mean, there's 28 recommendations, but here's some of the kind of most obvious ones. But first of all, it did propose legislation to strengthen protection for homeowners, and that became the Homeowner and Debtor Protection Act, which we'll talk about a bit more. It also talked about gaps in advice provision. Talked about gaps in certain types of advice provision, but also geographical areas where advice is more difficult to access than others. Recognised that advice provision wasn't as universal as it could be, and it also looked at ways in which we could get better at targeting advice at an early stage. For example, it talked about how do you target advice at the point at which people become redundant from jobs. They may not hit a crisis straight away. Redundancy often provides you with some cushion, but pretty certainly, or in a number of cases anyway, redundancy will lead to problems with debt if somebody can't secure other employment, other income. So I talked about advice. I also talked about the need for lenders to exercise forbearance, not to be too trigger happy in taking action against homeowners. And that was a kind of quite an exhortation, I guess, rather than a recommendation. The Scottish Government, of course, has very little leverage directly over lenders who are controlled largely by FSA, UK institution. But then there was a strong push for lenders to be kind of responsible in the way that took action against struggling homeowners. A really important one, and I'll talk a bit about this, is, and perhaps this might resonate with you today, is a call for plain English to be used in papers from courts and from lenders. I think that's always work in progress, and I'm not sure that we've finally become a kind of plain English country so far for legal action, but certainly a strong recommendation that we try and make things a bit more accessible for people who are often under quite a lot of stress. There were certain recommendations about legal aid, not particularly forceful recommendations, I have to say, but a number of recommendations that things be looked at in relation to access to legal aid for people with mortgage problems. One of the issues that came up again and again and will continue to come up is the fact that if you ask us how many mortgage repossessions have been in Scotland last year, how many borrowers are on certain levels of arrears, the answer is we don't really know. That's because FSA and CML don't provide that information at a Scottish level, which makes it quite difficult to assess the impact of reforms and assess where we are at the moment. So as a plea for better data, I think that's, again, work in progress. And there was also a set of recommendations directed at the UK Government around support for mortgage interest, the Homeowner Mortgage Support Scheme, and the role of the Financial Services Authority, which I guess would be directed at the ministers in UK Government. So that's a flavour of recommendations. You can see this report on the Scottish Government website still. I want now to look at that bit of the report which led to the legislation. The Scottish Government accepted the need for reform in the legislation and set about preparing the Homeowner and Debtor Protection Bill, as it was at the time, and now the Act. Now, it was passed in 2010, earlier this year. Commencement, as you know, is mainly at the end of this month, which is why I guess everyone's here in other parts of the country, because it's very imminent. There are two main parts. The first part, which I'm going to talk about principally, is around repossessions. This afternoon we'll talk much more about sequestration, trust deeds, that was looked at by a separate group in the repossessions group, so I wasn't so involved in that, and I'll leave that to other experts. So part 1, which is about repossessions, amends, I'm sure these very familiar piece of legislation, the 1970 Act, which has been the basic act for mortgage repossessions until now, the 1894 Act, which is still used in some cases, and, as I touched on, the Mortgage Rights Scotland Act, which is, up until now, the Act which has given some protection to homeowners looking for some respite if action has been taken against them. That's just the kind of skeleton, I suppose. Now, just as a quick overview of the Act, I'm not going to go into the Act in detail. I'll have to take questions because that will be covered by later speakers. Although I think it is worth covering some of it because it's kind of stuff that bears repetition, I think. First of all, the Act requires all mortgage repossession cases to go to court. That wasn't the case hasn't been the case until now. The one exception to that is as regards voluntary surrenders. Now, the rationale for that is that a borrower may say, look, I'm not going to be able to sustain this mortgage. If I've got to go through legal action here with delays that implies, all I'm going to be doing is racking up exposure to expenses and accumulating debt. I want out of this as quickly as possible. So in that kind of situation, there is provision for borrowers to say, look, I just want out as quickly as I can. Now that changed quite a lot in the course of the bill. The bill was originally drafted required the signing of a specific form in presence of a notary public, which MSPs in committee and some other organisations regarded as slightly onerous and unlikely to be used. So as the bill went through Parliament, that was changed to simply say that a borrower, if going through voluntary surrender, must do so in writing. Now, from my point of view, that's perhaps swung too far the other way. It begs the question of what voluntary is, whether people are getting good advice as to whether that is indeed the best course of action for them. And I would certainly like to see that as standard, people are directed towards advice if they're taking this course of action. I'd also like to see there being a standard form for doing this, so it's not just like a post-it note stuck in front of somebody and say, I'd like to get out of this, please. Anyway, that's voluntary surrender. The pre-action requirements I'll come to in a minute, and lay representation will be covered quite a lot today as well. I just want to talk about the recall of decree. As you'll probably know, currently mortgage possession actions are taken through ordinary cause in Sheriff Court. That's changing to be by summary application in the future. And so the bill, or the Act, builds in a specific measure to allow a decree to be recalled. So after the decree has been granted, there are situations where it's legitimate for that to be recalled. It can be recalled both by the borrower and by the lender, the creditor, right up until the day the sheriff officer's due at the door. So there's a specific provision for recall within the Act, and that will be covered by other speakers later on today as well. But I think it's probably quite important. If you're anything like clients we get shelters, quite often it's very, very, very late in the day. It is the 11:59 p.m. So it's a very important provision. And of course, as with any Act, there's transitional arrangements to allow us to move from the current legislative regime into the new regime, which again we'll talk about a bit later. So that's a very quick overview. I want to touch on pre-action requirements because I think these are at the heart of the Act. There's obviously important provisions. That this is the heart of what the Act's about. Now, I mentioned earlier on in England and Wales, there's been a pre-action protocol in the courts since November 2008. That was introduced very quickly when the recession was acknowledged. It doesn't apply in the sheriff courts in Scotland. Now, what the pre-action protocol in England and Wales does is says to creditors, here's things you must do before you will be able to take legal action against a borrower, a debtor. I'm paraphrasing quite a lot here, but here's steps you must take. The difficulty with the process in England is that it's a protocol. It has no strict legislative force. It could be ignored and the courts don't have to take account of it. So in Scotland, the government said we want to look at something a bit firmer than that. We want to look at something with a bit more teeth. Hence the pre-action requirements, which are essentially the same as the pre-action protocol, but you have to do them. So in practice, a lender who wishes to take action against a borrower in a repossession case will have to provide a form to the Sheriff Court that says, here's the steps I've taken, and this is the evidence that I've taken these steps and what the result was. Now that will have to be provided whether or not the borrower's present or represented in court. That's a crucial point. The court has to take account of it. It's not something we can set aside. So that's the kind of difference between pre-action requirements in Scotland and pre-action protocol in England. However, it is consistent with Mortgage Conduct of Business Chapter 13, which is the main document which governs the way that lenders should interact with borrowers with mortgage problems. The reason why it's consistent with MCOB 13 is that most lenders, in fact all lenders I guess, have operations across the UK and wanted not to be having a dramatically different regime in Scotland from England, and that was listened to, so it is consistent with MCOB 13. So as I said, in practice what that means is that lenders will submit a checklist to the court, and it will specify, here's the things that we've done to ensure that mortgage repossession is the last resort. Now, there's quite a lot of detail in there. It's covered in the legislation itself, it's covered in secondary legislation, it's covered in guidance. You have to read all three to get the full detail. But the three key areas, I think, are that information, clear information will have been given to a lender about the nature and size of the debt, including any expenses. You have to tell people very clearly what the debt is, including expenses, which is quite important. Secondly, they'll attempt to agree reasonable efforts to make arrangements to clear debt. So they'll have to show what they've done, other options they've used to ensure that debt could have been cleared. And thirdly, they'll agree to not take action if other arrangements have been made. For example, if someone's applying with some likelihood of being able to get support for mortgage interest or one of the very, very rare mortgage payment protection insurance schemes. If there's other forms of financial assistance likely to get, then a lender will agree to desist from action. So these are the kind of checks the lender will have to show they've taken. Second thing I'll just touch on briefly, and again this will be covered in more detail later, is lay representation. I think as today's audience shows, I mean, a lot of you are, I think, as advisors for voluntary organisations. I know there's some solicitors here as well. But there's a new provision that lay advisors, that's advisors who are not solicitors or advocates, can represent people in court. But it can't just be your Aunt Janet or whatever, unless your Aunt Janet's an advisor with a CAB or an advice centre. You have to be, first of all, part of an authorised organisation, like a CAB or shelter or law centre or so on. And secondly, you have to show the sheriff that you're competent throughout the proceedings. So simply being an advisor for one of the authorised organisations isn't enough. If the sheriff decides that actually you don't know what you're talking about, then they can say you're not fit to represent this person. Okay? And the last thing I want to look at is the challenge of implementation. Again, this is probably as much a discussion point as anything. But just a few things I've put up here. First of all, as I mentioned earlier on, there's a transition period. We're going to have some cases in the court already which will be going through the existing regime, the 1970 Act, 1894 Act, using the Mortgage Rights Act, potentially, all these things. Now, they're going to continue. So we'll have two regimes working in tandem. We'll have the old regime and the new 2010 Act regime. That's just one of these things. It'll pass, it'll be messy, and it'll be complicated, but it will pass as new cases come through the court. The second thing, I guess, I expect this audience today to be interested in this, is do we have a advice sector capacity? It's all very well given new rights, new processes, but do you have the capacity to be able to assist people to exercise these rights? That's a moot point. We'll know. You can never be sure, I think. There have been steps taken to boost capacity, and there is continuing a group which is convened by SLAB looking at advice provisions for homeowners, but it's never going to be perfect. Thirdly, in plain English, so I think the Scottish Government's acknowledged that plain English isn't yet been achieved. Some of the forms that have been produced under the new regime are better than previously, but they're still quite hard to read. I find them hard to read, and I think I've been immersed in this for about 2 years, so I'm thinking if I was somebody who's really stressed about debt and stuff like that, I'm not sure they're yet as easy to read as they might be. And I think the Scottish Government's recognised that and has continued to want to improve them. Fourthly, is the issue of expenses. I kind of regard this as one of the unfinished business of this process. It was raised a lot in the repossessions group about what is the right balance between the debtor's interest and the creditor's interest in terms of the expenses. As you all know, a standard mortgage contract and standard conditions mortgage contract allow a lender to recover their expenses or add their expenses to the borrower's mortgage account. In the course of the bill going through Parliament, Shelter asked one of the MSPs on the Parliamentary Committee to put forward an amendment which would have said that if a lender had been judged by the Sheriff not to have followed the pre-action requirements, i.e. done all the things they should have done prior to taking legal action, then they wouldn't be entitled to add expenses onto the borrower's account. In a sense, what that's saying is, you have to do what you should be doing, which is right, before you're entitled to levy expenses. The Scottish Government said it was sympathetic to that, but unfortunately it was judged to have been straying into areas of reserved competence, it dealt with contract law, and therefore to be invalid. So we are kind of stuck with that one a wee bit. It is still possible to add expenses, and I think that's an area we're looking at in the future. Fifthly, there's an issue about the economic environment. We may be through the worst of the recession, who knows, but we've got public sector employment changes. We know the public sector is going to shed jobs in the next year or so, and as I said, unemployment and repossessions are inextricably linked. We also have had interest rates very low the last 2 or 3 years. They're not going to stay low forever. The only way for interest rates is up, and some people who are clinging on just now may start to struggle when interest rates go up. So I don't think the economic context is at all benign as yet. And finally, and I guess this is an obvious thing to say, we're talking today about a piece of legislation which is new and which can help homeowners, but it's only part of what needs to be done. Okay?